This is the fourth segment of Lesson 16 on discharge performance. Segment 3 covered the termination of a contract due to its completion, either by complete performance or substantial performance. In this segment, we'll explore what are the obligations of one party if the other party breaches the contract in a material way or undertakes what's called an anticipatory repudiation or anticipatory breach of contract. We'll also explore the doctrine that the divisibility of contract where a material breach has occurred, which might lead to partial payment being made, even though there has not been either complete performance or substantial performance. First, material breach of contract. If the other party to a contract you have entered into has not adequately undertaken the work, in other words, there's been no complete performance, no substantial performance, do you have to pay? As discussed in segment 3, if the breach by the other party is minor, then substantial performance has occurred and you may be required to pay, less a deduction for any cost that you incur finishing the job. But what if the breach of contract is a major breach? We call this a material breach of contract. It's something that matters substantially. The general rule is this: where there is a material breach of contract, generally speaking, the other party is excused from performance. Generally doesn't have to pay, with a couple of exceptions. The first being that, for example, your obligation to make payment may be just suspended. You may still have to make payment if the other party is to be permitted a time to remedy the breach. And a lot of times in breach of contract cases, where another party has not performed, you have to contact them and say, hey, you're in breach of contract, this job is late, I will now give you 30 days to perform, or some other reasonable time period if you haven't specified that in advance in the contract. In other words, generally speaking, even if the other party is in breach of contract, unless your contract explicitly states a completion date and no contingencies have occurred, like bad weather that's extraordinary or something like that, that causes an unforeseen delay in the contract. If that's the case, where there's this material breach, generally speaking, you have to give the other party a reasonable period of time to basically get the work done. But if the work is still not done and this material breach of contract persists, then as a general rule, you're not required to make payment. Let's discuss a couple of examples here. In the first one, suppose you order a car from a Lexus dealer, and with that, you were going to get a stereo and a Bluetooth connection with it and fancy hubcaps, but the Lexus that was delivered to you lacked all of these things. First off, the Lexus 460H is, in my view, the best car in the world today in terms of practicality. Obviously expensive. But let me ask you, if you go to the Lexus dealership after ordering this car, and this car that they want to give you does not have a stereo with a Bluetooth connection, it doesn't have fancy hubcaps, can you be forced to accept delivery? Obviously, it wouldn't be good customer service on behalf of the Lexus dealership. They'd be very unlikely to do that, to force you to accept a car. But the question is, legally, could they be forced to have you accept delivery? The second question, suppose a used car dealer promised you the one and only Ford Mustang that was driven by Steve McQueen, a very famous actor of my generation, in the movie Bullitt, and then later presented to you, not with that car, but with a Mustang of the same model year that was driven only by me. So very same model year, same car, but not the car that was used in the movie. Can you be forced to accept delivery? Pause the video for a minute and consider your answers to these two questions. Let's give you what my take is on these answers. As to the Lexus, substantial performance occurred. And yes, you must accept delivery. You have to ask, was there complete performance? Was there substantial performance? If there was neither of those, if this was a material breach of contract, then at that point you must then examine whether or not you had to give them a reasonable time to complete it. So substantial performance in this case likely occurred. However, some courts might suspend your requirement to make payment for a reasonable period of time to permit the dealership to install the stereo and the hubcaps in a case like this. If a court said that you must continue to accept it, then you have a defect. It's a minor defect in the goods that you were promised, and you are able to deduct the cost of buying and installing a stereo with a Bluetooth connection and fancy hubcaps. You don't have to pay the full price. So you could withhold that payment until the dealership fixes that later, or you could withhold payment and then get another dealership or somebody else to install the stereo and the hubcaps. As to the example of the Mustang, a car driven in a famous movie is likely to be a unique vehicle. It has a special value associated with it because it was driven in that movie in various chase scenes and the like. That is altogether a different car than the same model and year car driven by Professor Rhoades. Completely different values. In that case, a material breach of contract occurred, and you are excused from going forward and making any payment on that. Another doctrine that we have to look at is this concept of anticipatory repudiation. It's basically a material breach of contract in advance. The other party lets you know that he or she is not going to do what they are legally obligated to do. Even though they have a contractual duty to perform services for you, to provide goods to you, they might state to you, I'm not going to do it. Or by their actions, it is indicated that they are not going to fulfill this contract. So the actions or circumstances might exist that constitute anticipatory repudiation. This is also called an anticipatory breach of contract, and where this occurs, you no longer have to go through with what you promised to do, for example, make payment or whatever else you are obligated to do. However, we also have to keep in mind kind of an exception to this rule, that if there's an anticipatory repudiation, if the other party lets you know in advance that they are not going to proceed with the contract and do what they're obligated to do, they can later retract that statement. That's a retraction of an anticipatory repudiation. When can that occur? This can be done until such time as you change your position in some way or state you are in material breach of contract. For example, if someone states they're not going to deliver certain goods to you in their contract, and without saying anything, you order the goods from another party, then the other first party's repudiation cannot be retracted at that time because you've acted in what's called detrimental reliance upon their statement. Or you could simply say to them, you are in material breach of contract, I'm going to make other arrangements, and let it go at that. And again, you're not obligated to pay for a material breach of contract. Let's consider this example. Suppose that I enter into a contract to perform a dance in a bear costume for you for the sum of $100. But then I say to you, I doubt that I will perform. Has there been an anticipatory repudiation? Pause this video for a second, think it out, and answer the question to yourself before going forward. The answer is no. Merely because I express doubt as to not performing my contractual obligations is not in itself an anticipatory repudiation. I have to be very clear. I am not going to do this. In this case, I said that I doubt that I will perform, which is something altogether different. How about this example? Evelyn contracts to buy 100 boxes of glassware from Kim. Just before Kim is about to deliver all of those boxes, Evelyn tells her that she won't accept the goods and won't pay for them. But 10 minutes later, Evelyn calls Kim back and says that she'll go with the deal after all. Now, during that 10-minute interval, Kim has done nothing. When Evelyn calls back, however, Kim tells Evelyn, after Evelyn says that she'll go through with the deal, that she won't deal with anyone so unprofessional and that the deal is off. So which of the following is most true? Now remember, Evelyn first said that she wouldn't accept the goods. She called back. She said, "I've changed my mind. I will accept the goods." But then Kim responded, "You're being unprofessional. I'm not going to deal with you at this point." Which of the following is most true? First, Kim may cancel because of Evelyn's anticipatory repudiation. In other words, Kim is discharged from performance. Kim may cancel the contract because of Evelyn's non-conforming conduct. Kim may not cancel the contract because she did not proclaim the contract to be in breach. She didn't proclaim what Evelyn said at the beginning to be a breach of contract. Or Kim may not cancel because Evelyn had an option contract. Which of these answers is correct? Pause this video for a few seconds and answer the question to yourself before going forward. Let's look at the answer. The answer is C. Kim may not cancel because she did not proclaim it to be a breach of contract, and she did nothing like ordering the glasses from someplace else that would have been constituted an action of detrimental reliance. Although there was an anticipatory repudiation, that anticipatory repudiation was later revoked or rescinded, and that's possible if the other party has if the other party has not treated the anticipatory repudiation as a material breach of contract. In this instance, Kim did nothing. So why are the other answers incorrect? Answer 1, Kim may cancel because of Evelyn's anticipatory repudiation. Yes, Kim can cancel, but the issue in this case is not whether there was an anticipatory repudiation or anticipatory breach of contract, but whether the next step in our analysis, the exception to that rule, is was there a rescission or a revocation of that anticipatory repudiation? Second is, can Kim cancel because of Evelyn's non-conforming conduct? We haven't studied anything that relates to non-conforming conduct. I hope that you didn't choose that answer. And the fourth answer is Kim may not cancel because Evelyn had an option contract. This is not the case of an option contract. This is the case of a contract itself. We don't have a contract to enter into a contract in this case. So that answer is not correct. Let's go on and explore this next issue, which is really an exception to this concept of being excused from performance, no obligation to pay, where there's been a material breach of contract. Where it is possible to divide a contract into separate parts. For example, there's a sum that you agree to be paid by a week or an hour for your services, or there's a number of goods to be delivered and you've only received a part shipment of those goods. Then the courts can still award to the other party a sum for the separate parts of the contract which have been completed. So the question is the contract divisible in the minds of the courts? Let's consider this example. By contract that was entered into between Ritchie and Atkinson, Atkinson agreed to deliver a cargo of 20 tons of iron and 10 tons of rope on his ship for delivery to Ritchie. So Atkinson was a shipper. The price agreed was $10 per ton for the iron for the delivery and $1 per ton for the rope, not the iron. Atkinson only delivered part of the agreed quantity, 10 tons of the iron, about half, and 2 tons of rope, less than half, only 2 out of 10 tons delivered. Ritchie argued that the contract had not been fully performed and therefore no payment was due. So let's ask some questions. Was there a complete performance of this contract? Was there a substantial performance of this contract? In other words, only a minor breach? Was there a material breach of contract that excuses performance, But even with a material breach of contract, was the contract divisible? And if so, what amount, if any, was owed to Atkinson? Pause this video for a minute and consider the answers to those questions. The answer is essentially this. There was not complete performance, obvious. There was not substantial performance. Less than half of the goods were delivered, and although half is not the dividing line, every situation is fact-specific. Generally speaking, anytime you see less than half being delivered, there's a material breach of contract. So we have a material breach of contract, but then the question is the contract divisible? Can it be divided into separate parts? Because the parties had agreed to a price per ton? And the answer is yes. Atkinson is thus entitled to payment for the amount that he actually did carry. However, Ritchie is entitled to damages for non-performance in relation to the amount that was not carried, and if it cost him more to have a partial shipment delivered than an entire shipment at once, he could deduct that, and he might also incur some consequential damages, which we'll study later.